We continue to watch this parade of screen grabs taken from surveillance cameras that were set up at a restaurant and a liquor store that were right in the neighborhood of the bar, the Austin City Saloon, where this shooting happened in the Lexington, Kentucky area. So as we watch the prosecutor kind of get these pictures together, put them up on the screen one by one, I want to bring our afternoon guest in. Ashley Willcott is with us here on the Law and Crime Network. Ashley, always good to see you here.
Good. Thank you, Aaron. Good to be here.
Yeah, so let's talk about this. I mean, this case started off with myself and many of the other hosts here asking a lot of questions about exactly how the prosecution was going to try to tie this shooting to these two defendants in particular, because some of the eyewitness descriptions were so shaky. Really, the only eyewitness description that they had was the victim of another crime in a hotel that happened 6 days before the actual shooting of Jonathan Price. And that witness said, well, it kind of looked like one of the defendants, only it looked like he had another guy's nose. And then that same witness had been making some racially fueled Facebook posts about the crime, which really detracted from his credibility on the stand. But now we've got the license plate number, Ashley. We've got, you know, the two men believed to have borrowed the car. We've got that car in the neighborhood where the shooting happened. We've got some cell phone pings from the defendant's cell phone. So they were in the area. Does that necessarily mean that they're the ones that attacked this couple and pulled the trigger?
No, it wouldn't necessarily mean that. So one of the things to keep in mind, Aaron, is during the opening statement, the prosecutor started, remember, with the audio that's the heart of the case, where it's the wife calling 911 and saying, this is what I'm seeing and this is what's happening, and getting more and more frantic because she recognizes her husband is in danger, perhaps dying right in front of her. That's the heart of the case. But the prosecution then admitted and set out all the small pieces of evidence that it expects to present and produce in order to paint a picture in which they connect these two defendants to this particular murder. So each piece in and of itself is not sufficient, but I think the goal, hope for them is by the time they lay it all out, they've clearly connected these two defendants to the shooting and murder.
Yeah, you know, I agree that that's the tactic. The question is how successful it's becoming. And look, I'm more convinced now than I was a couple of days ago when we just had these sort of shaky identifications. But as you said, Ashley, and I think that you're correct, it's not surefire. The bottom line is I agree that these two were in the area. Are they necessarily the ones that actually pulled the trigger? Well, that is yet to be seen. But it is getting stronger and stronger. So this trial is expected to last 4 weeks. We're in the second week of it. They don't meet Fridays because the court handles other business on Fridays. But is it possible that we could just see more and more of this evidence pile up and that the burden of proof eventually gets met for the state?
Absolutely. I agree with you, Aaron. At this point in time, I don't think enough evidence has been presented to say, oh, we have a clear identification of these two defendants. But I think that by the end of it, we really might. Now, there was also previous testimony by a detective about a lineup that he did in relation to the robbery that was committed. And he was very thorough in explaining, and the prosecution was thorough in asking questions to ensure that the lineup was done correctly. So there weren't real challenges to the actual lineup. So I think with that type of evidence, it might build up, but we're not there yet.
Yeah, you know, and just to let folks know what's happening in the courtroom right this moment, there's another sidebar here. Keep in mind that this is the kind of case that oftentimes is ripe for objection, and you're looking at that sidebar right now because you have two defendants, and as a matter of constitutional fairness, they get their own attorneys. That oftentimes is because sometimes one defendant will wind up turning on the other and seeing where that tactically takes him. But that hasn't happened here, but they get separate attorneys because the tactics to defend one may actually conflict with the tactics to defend the other. And so with a couple of defense attorneys, it runs the risk for more objection. And here, Ashley, I thought this was a little bit bizarre. The prosecution was bringing in those screenshots of surveillance recording footage, and the defense acted like the defense really hadn't seen them, even though the defense knew the content, and there was a bit of a back and forth there. If you're going to use screenshots from surveillance footage that you have given to the other side, shouldn't you have to give the screenshots ahead of time as well?
You should, and you already raised the point that some judges demand that you follow the rules of evidence strictly and some don't. But here's my position as a judge. I expect attorneys to do it for this reason, for appeal purposes. So even if you're not accustomed to it, you better be prepared to do it. Those pictures should have been seen by the prosecution ahead of time, and they should have been introduced into evidence correctly. So you don't have prosecution saying, hey, I don't think I've seen those. There's just a best practice, and that one example wasn't necessarily best practice when it comes to admitting evidence.
Yeah, and I remember this lengthy list of evidence production and introduction rules from my trial advocacy professor. It was a 6-step process. You know, you have to mark something for identification, you have to show it to the other side, then you have to give it to the witness, lay the foundation, offer it as a full evidence exhibit, and then use it in front of the jury. And I remember this process because my professor forced me to follow it every single time. And I think I can only recall one trial that we've covered out of all the trials we've covered here on Law and Crime where it actually rolled out that way.
That's right. You know, it's a rarity, regrettably. I teach a NETA course, and that's for trial skills. And it's one of the basic trial skills we go over with even the most experienced lawyers, because lawyers often get accustomed to the particular courtroom in which they practice. Not all courtrooms require formality, and so some of them get accustomed to it, doing it without following all the steps. But the steps you just said, Aaron, are the exact steps that you're supposed to follow. Then you ask to publish it to the jury at the very end of that, and that's best practice. That's what every trial attorney should do when they're introducing those into evidence.
Yeah, you know, I agree with you, Ashley, and it looks like this sidebar is going to break up any second now and that we might see questioning resume of this particular witness. But, you know, look, not only is it procedural, but the reason that we have the procedure is because it is fair. That's why we've got it going out that way. That's why it rolls along that way. And even if my court didn't require it, I mean, unless a judge chastised me and told me to move along, I think I'd be inclined to use that formal 6-step process if I were practicing, just because it's more fair to the other side.
Not only is it more fair to the other side, Aaron, but it prevents an appeal for that reason, right? You want to do it the right way to take away any unnecessary grounds for appeal.
Exactly, and still waiting to get a sense of where they're going in court. We're waiting for this sidebar to break out, and they're still apparently going at whatever issue is going on here. So, look, we're going to take a quick break here, and we'll be back with more in just a second. Welcome back, everyone. We're talking about the Jonathan Price case here on the Law and Crime Network. And as we were about to go to our break, the court took an afternoon recess. Usually they last about 15 minutes. As soon as testimony picks up, we'll go right straight back to the courtroom live. In the meantime, we want to get you caught up to date on a case that we're expecting to cover starting tomorrow here on the Law and Crime Network. Daniel Grice is accused of 5 counts of murder for an alleged drinking and driving car accident. Let's get you caught up to speed on that.
The murder trial against 57-year-old Daniel Grice is set to begin tomorrow in Kentucky. Grice is accused of killing a family of 5 in a car crash last October. Police say he collided with the Pollitt's family vehicle while driving under the influence, going nearly 100 miles an hour. When Grice was receiving medical attention after the crash, it was revealed that his blood alcohol level was between .083 and .092, over the legal limit in the state of Kentucky. Grice is facing 5 counts of murder for the deaths of 26-year-old Rodney Pollitt Jr. and 27-year-old Samantha Malone, as well as the deaths of their young children, 9-year-old Halian, 8-year-old Brendan, and 6-year-old Kaylee. Grice is facing 20 to 50 years to life in prison. For Law and Crime, I'm Jesse Weber.
That case we are expecting to pick up starting tomorrow here on Law and Crime, so stick with us for that. In the meantime, let's talk a little bit more about the Jonathan Price case that we're in right now. Ashley Willcott is still on the line with us. Ashley, we've said before that it seems like the prosecution is sort of tightening the noose a little bit on these 2 defendants, in the sense that there is more and more of a sense that they were in the vicinity of this attack when it happened. So I'm starting to get a little bit more convinced that maybe it was them, that maybe the state is going to tie this together a little bit more neatly than perhaps we initially thought. But, you know, I can't help but get over a couple of other pieces of evidence that are not in the state's favor. One is that there is some unknown person's DNA under victim Jonathan Price's fingernails. And look, he was involved in a fight It doesn't necessarily mean that one of the defendant's DNA would be transferred, but an unknown person, some kind of a scuffle, what's going on? I mean, that's one piece of evidence that's not helpful to the state at all. And there are others. You know, you've got problematic identifications, you've got the DNA. Do you think it's possible that the state just isn't going to be able to pull this one out?
It is possible, and especially if you take in mind Megan, the wife who was shot and was involved in the altercation, her description of one of the defendants was fairly generic. It was white T-shirt, dreadlocks, African American, and a silver gun. And that was the extent of the description. And so without a positive ID of someone saying that unequivocally, yes, is the person I remember to be the defendant, there's absolutely a risk that they're not going to be able to pull it together and put all the pieces together to convince a jury. You know, one person with reasonable doubt, that's all it takes, as we all know, and they're not going to convict these defendants. So that is possible. The prosecution may not pull it out.
Yeah, you know, I want to talk with you about another hearing that we covered today on Law and Crime earlier, and that's the Jeffrey Willis sentencing in the Jessica Herringa case. This is a defendant we've covered twice here. He was accused of killing a young mother named Rebecca Bletch. That resulted in a conviction. Then he was accused of killing another young mother, Jessica Herringa. That resulted in a conviction after only, I think it was an hour and a half of deliberation, something very, very short. And Ashley, look, the way that the prosecutors got there was they had a teenager who claimed that she was attempted to have been abducted by Jeffrey Willis, and then they used her description of the van to track him down, and then they tied him to both of these other crimes. Well, Jeffrey Willis gave a statement at his sentencing in this second case that he faced. He really lashed out at the police, the prosecutor, accused them of corruption, accused them of not handing over proper evidence for him to review. He also lashed out at the press. So if you missed this earlier, folks, this is worth listening to. Jeffrey Willis, a defendant who has twice been convicted of murder, giving this statement at his sentencing in the second case. That was at least a little bit of the statement that Jeffrey Willis made upon his sentencing in the Jessica Herringa murder case. Ashley Willcott, former juvenile judge and current practicing attorney, is with us now. Ashley, I don't know if you got a chance to listen to a lot of this, but, you know, look, I might make myself unpopular for saying this, but I expressed some issues with the way that this guy was convicted from the get-go. He actually sort of exaggerated some of those issues in my head, but it seems like a lot of people are happy with him being locked up and the key being thrown away. This is life in prison without parole. But he gave a grammatically correct, relatively well-spoken statement saying that, you know, look, he made some pretty wild claims there. I don't know personally whether they're true or not, but what a statement, I guess, is the last thing I have to say about it. Did you get a chance to hear it all, and what did you think?
I did hear it all. He is articulate. He made some good points. But I also take into account one of the jurors that was interviewed made a statement that throughout the duration of the case, as it was going, he did not feel like there was enough evidence as a juror to say that there was beyond a reasonable doubt this man committed this murder. And it went on, and then he said all of a sudden there was a turning point, and every little piece of evidence for him added up, and they said, wow, you know, we think he did it.
That's interesting, you know, I mean, and look, I can understand how it would slowly pile up and pile up. We're talking about that right now in the Jonathan Price case, that at first it started off like what seemed like a relatively weak case, and then as more evidence comes in, our minds start to at least potentially flip a little bit and implicate the defendants a little bit more, a little bit more, a little bit more. And look, that's the way it should go. The defendant's supposed to walk in a courtroom with a presumption of innocence. In the Jeffrey Willis case, how they got there, though, is I don't know what you think about this, but I come from a state where, you know, you try your cases separately unless there's really a true common scheme or plan among them all. That, you know, for instance, someone uses the same modus operandi, or someone uses the same exact basically scheme or plan. They're operating the same exact way, going after very, very similar sorts of victims. And then maybe you can start to try a number of instances together. Otherwise, things get tried separately. But in this case, you've got the teenager who claims that she was abducted coming into both of these murder trials. So you've got her on the stand. You've got an emotional and a frantic 911 call being played in court that show that teenager in hysterics. And then so people immediately believe that Jeffrey Willis is a monster based on the emotion in that call. Okay, well, Jeffrey Willis gets up there and says, wait a minute, she had a juvenile court record, but it was sealed, so we couldn't cross-examine her on it to question her own credibility. I'm seeing confrontation clause issues in that, if it's true.
Right, and not only that, but he claims that she was on meth and that affected her behavior and what she said. So it's tough when you have a juvenile because the laws are there to protect the juvenile, but it does, when it's sealed and he can't have access to the sealed record, then he's unable to ask questions about whatever offense or whatever situation that was in juvenile court. So the laws are there for a reason to protect the juvenile, but I understand why he may feel like, look, I couldn't confront this juvenile because I couldn't access the sealed record. But then some might argue, and I see both sides of it, some may argue, hey, she's identified him. Yes, it's emotional. She said this happened, but that's only one small piece of evidence. That doesn't mean that he actually killed anyone else. And so the prosecution still had to not just have her identification of him and saying he tried to kidnap me, but then also had to go from there to prove that he actually murdered someone else.
Yes, and I understand the strongest piece of evidence that they seem to really have against this guy is you got a van that looks like his in the area, okay, even though you've got some other people saying that they didn't recognize him driving it. And you have parts that were apparently off of some kind of a scope or some kind of a light or a device that attached to that defendant's gun that were found in the parking lot. And I wonder, was that the piece of evidence that you had heard was the final link that made the most sense for the jurors?
The juror that spoke openly about this, absolutely. That was what he said was one of the pieces that really sealed the deal for him and made him feel like this is absolutely done, the crime. This crime was done by this individual defendant. The other thing he said, which was interesting, was there were two jurors that apparently were on the fence, but they asked questions about, but what about this and what about that to link the evidence together. He says the other jury members said and pointed out and reminded those jurors of testimony and evidence presented. And once they were reminded, they said, well, that's right. That does cause us to put it all together and find the links. And yes, we think he did it. So it's a really interesting case from the perspective of the jury putting all the evidence together to come up with a conviction of this man.
Yeah, look, I mean, that's the way jurors are supposed to work together. And talk about a case that's ripe for a conflict of laws analysis. You've got sealed juvenile records that could have been used to cross-examine one of the key witnesses. Those records weren't unsealed, so it allowed that witness to basically testify against this defendant unabated. At least that's the accusation that the defendant made. You've got that. You've got all of these other bad acts, or 404B evidence, and the rules of evidence, if you're following the federal rules, coming into all the other trials. And Ashley, what's your thought on that? Because I come from jurisdictions where that just usually is not allowed by judges unless there is a really, really, really strong link. You know, the same exact parking lot where people were attacked, the same exact van. Like, there would have to be a link of similar pieces of evidence that tie everything together. Here you've got victims who look different, they're different ages, you know, and it just, what do you think? I mean, is it too much to throw it all into one case together?
Well, I think that's the legal debate. So some jurisdictions, like you already explained, Aaron, it's prior bad act, and it can be something that's not a similar transaction or type of crime, or like you said, the way that the crime is conducted. And then there are other jurisdictions where it very much has to be a similar crime before the judge will allow it, or the jurisdiction will allow you to introduce it into evidence. And so I think you have two different arguments. One is prior bad act. It's not as unlikely that he would have committed a subsequent subsequent bad act, even if the way that he did it was not the same. And then you have the opposite argument, which is, so what if he did one bad act? If it's not similar in nature to the one that he's now being accused of, then it shouldn't be admissible. I think in this particular case, because it was the less stringent standard of prior bad act, even if it wasn't the same manner of death or same type of act, I do think that opens up, makes it subject to appeal, and we may see an appeal on those grounds. But every jurisdiction is a little different.
Yeah, I'm certainly curious to see how that's going to roll out. I know a lot of jurisdictions just say from the standpoint of fairness, you're supposed to get one bite at the apple on each crime and not throw them all in together. You know, look, if somebody jaywalked when they were 14, does that necessarily mean that they shoplifted when they were 16? Sort of thing. And that's the debate. I think you probably articulated it a little bit better than I did. But look, we do have some sound from the Jeffrey Willis sentencing hearing. The defendant himself getting up and saying in front of the judge that he wants to clear the record, he wants to unburden his issues with the case, and he goes on to slam the jurors for allegedly sleeping during his cases. He goes on to slam the police, who he accused of being corrupt, of basically planting evidence against him, and he goes on to slam the press, at least a little bit, for the way that the press covered a number of his different proceedings. So let's listen to Jeffrey Willis now. That was the end of the statement from Jeffrey Willis speaking at his sentencing hearing in the the Jessica Herring case. Ashley, I'm starting to blur them together because basically they were blurred together within one another's trials. And, Jeffrey Willis saying there's a good old boys network. He's accusing the police of lying, of perjury. The bottom line here sounds like he's saying that the bullet that was recovered from the body of Rebecca Bletch, okay, this is the other case, that was linked back to his gun. He's saying that that was somehow a test fire bullet, as I take it, and that it was basically testified to by a forensic expert. Oh, no, that didn't come from a test fire. It came from the victim's body. And that's why we link it back to the gun. He's saying that that bullet really didn't come from the body. And look, you've got a litany of complaints about police misconduct, but that seemed to be the key one. Do we buy that? Do we not buy it? Do we just throw it out and say that this is a guilty guy who's trying to grasp at just about anything to keep himself from spending the rest of his life behind prison bars?
Well, it's really hard to know how the jury perceived his credibility, but that's exactly what he's trying to do. And he's trying to say, hey, due process violated. It's a constitutional right. But listen, the scales of justice, and I'm a defendant basically that doesn't have the means or ability to do additional forensic testing and test the bullet and prove what I know to be true about this bullet. And without all that, I can't prove my case. But listen, they had it wrong. Good old boy network. Poor me, basically. I felt, this is my personal opinion, I greatly respect that every listener and you, Aaron, may disagree, but I felt like he pulled out every possible argument he could think of to cast any reasonable doubt in any one juror's mind. And so everything he could think of, he threw in with the kitchen sink to say, find one of these reasons true so that you don't convict me.
Well, look, this isn't even the right stage of the trial for that discussion to be going on. Why speak now and not when he was facing jeopardy? This is sentencing. This isn't the trial.
Right. It's like now he's mad and he wants everybody to hear about it. And so I didn't even feel like he was trying to say, give me the minimum sentence possible. I felt like he was trying to say, all of you have gotten it wrong. It's all of your faults. I couldn't have a fair trial because I couldn't afford it. And I couldn't disprove the evidence because I couldn't afford it. And here I am, and you got it wrong. I mean, I truly feel like he took this opportunity instead of dealing with the sentencing part or doing it at the trial to say, you are all wrong, and here's why there was reasonable doubt, and you got it wrong. Well, it's interesting, isn't it?
Yeah, I mean, do we believe him? Do you believe him, I should say? You don't believe him at all?
I don't. Now, again, I respect I'm not there in person watching it, but I did not find him credible. I did not believe it. I found like he was just trying to throw anything out there he could think of. He's very articulate. He's aware of what the Constitution says and provides for. That's all very good, very positive, but I still didn't believe what he was saying.
I'll put you on the spot here, Ashley. Even if he's guilty, did he receive a fair trial under the standards that he was just talking about?
Well, I do have a problem with some of the findings. And again, you know, it's always easy to play Monday night quarterback, and I'm not trying to do that. But I will
run
say,
for the appellate bench. You know, this is what I'm asking you to do. You can be an appeals court judge on Law and Crime.
No, thank you, sir. No, I just question some of the things that he raises in terms of things he was not allowed to do. The denial of unsealing the juvenile court record, that just means he didn't get to cross-examine or use that information to question that particular witness. The other thing that I noted is he had some arguments that he made, and Aaron, I didn't watch these in their entirety, but against his public defender and the attorneys that he had representing him, and there was a loss of some attorney notes and conversations. And so did those things violate his rights and due process rights to have a fair trial? I think arguably they might have. And so there are some issues that are constitutional issues Court of Appeals might consider.
Yeah, I'm really going to have to keep a close eye on this as it goes through the appeals process because, look, they could just turn around and say, well, harmless error, this didn't add up to be enough, or those juvenile records should be sealed. Look, it could go on and on and on, and it probably will. So who knows? I mean, we could be back here in a few years watching another Jeffrey Willis trial, not sure. But look, the prosecutor had a quick rebuttal here, if I can use that word. It was a retort, a response. And the prosecutor said in this, basically, well, look, the sentencing is fixed by the law. There's a mandatory sentence for this. But he basically took the time to pat the local authorities on the back for the way that they handled the case, despite the defendant's attack. So let's listen to this. There in West Michigan won the hearts of many of the people in the gallery there, with them bursting out in applause at his defense of local law enforcement. Ashley, what did you think? He says, you know, in my career, which is 19 years long, I've never seen as dangerous a man as this, and all the local police put all this overtime in and put off vacation time and gave up weekends, and I doubt they were working for free, but the prosecutor certainly made it seem that way. How did you react to this?
Well, I think that he was just trying to rehabilitate. Think about law enforcement, the state, all the people that put the work into it. Those are his people. So I think he wanted to have an opportunity to try to rehabilitate and say, listen, they did do a good job. But I also felt like his statement was to play to those in the gallery and victims' families and anyone else who was there to observe, to say, hey, we've done this and everybody put all their time in and we found the right person and this was the right thing and he was a dangerous man. So I feel like it was a little bit to appease everyone listening to it and those who have been victims of these particular crimes.
Well, look, I mean, what kind of a retort was it, though, if it doesn't go back and address the factual assertions that were made? It sounded to me like, oh, we've been doing this forever, just trust us because we're the authorities. He didn't go back and say, no one lied on the stand, no one planted a bullet. This process of tying all the crimes together, 100% fair, and you've got to live with it. This process of sealing the juvenile records and not allowing you to cross-examine the juvenile, completely fair, too bad, live with it. That's the way the law works, and it was fair. Why didn't he do that?
I don't know. And in fact, he went one step further to say, basically, there's not a lot I can say about the sentencing or that I am going to say because, Judge, you're going to sentence what you're going to sentence. So I felt like he focused on the sentencing only. He didn't want to go backwards. He didn't want to do a closing argument that he would do after the conviction to say, or prior to the conviction after all the evidence, to say, we didn't do any of these things. We did everything right. Instead, I think he focused on the sentencing and said to the court, listen, you're going to sentence what you're going to sentence. We're asking for maximum time, and here's why, and sat down.
Yeah, certainly an interesting statement from the convicted defendant himself. We keep in mind, convicted of killing 2 women and attempting, at least the accusation goes, to abduct a third. He gave that statement on his sentencing. We're going to get you caught up on the top crime stories of the day before turning back to the case of a U.S. Marine corporal who was shot and killed while defending his wife during a robbery. 90 seconds of terror in the voice of Megan Price. She was shot in the leg. Her husband was shot in the heart. That call made as life was slipping away from Jonathan Price. Ashley Willcott is on the line with us. Ashley, just horrible to listen to that again. It must have made a mark on jurors, but I'd like to think that it's not the most important piece of evidence in the case when we look at it from a big picture.
I agree with you. So I think the prosecution was smart. They played that at the very beginning of opening. And what does that do? It compels the jurors to listen. It gets their heart involved. It gets them emotionally charged because it's a devastating, horrible crime. But then the fact of the matter is now, after that, they then have to focus on, there's the call, there's what the wife says happened. But now you've got to focus on what's the evidence to actually link the two defendants to the crime and prove that they murdered her husband and that it was these two individuals who did that.
Yeah, you know, I mean, oftentimes we listen to these things, they're emotional, they're hard to listen to, they're hard for witnesses to listen to when they're back up on the stand, but the witness has to be the one that puts the evidence in trial. She's got to get up there and say, I'm the one that made the call.
Yes, I agree, Aaron. And the thing I'll say about this witness, I watched almost all of her testimony that you all broadcast, and I found her very credible, heartbroken. This happened in 2014. Here we are in 2018. Of course, you always are going to be traumatized, devastated by such a loss, but look at her raw emotion. And I felt like she was very credible and she answered questions very well. If I were a juror, I think I'd believe everything she said and how she identified the people involved.
Or didn't identify the people involved in this case, because
Yes.
she was careful to say that she remembered some things clearly and she couldn't remember other things. And look, I think that adds to her credibility. Clearly she's heartbroken. You heard in the call, you know, I can't be without my husband. I need my husband. And so our hearts go out to her. But then when you get into the substance behind the emotion, I think that she's very smart. She's being careful to testify as truthfully as she can. She probably wishes that she had more information to provide. She just can't, and she's honest about it. In other words, one could say that maybe she's the perfect witness.
Right. No, I do agree with you. And she was very clear about, and she was questioned some on cross-examination about the defendant and what they looked like and what they were wearing. And she was, like you said, Aaron, very believable because she said, I don't know, a white T-shirt, dreadlocks. She was consistent. And again, what you said, what she was able to tell and what she wasn't able to tell.
We want to listen to some more of her testimony up on the witness stand. We'll be back with some more analysis in this case in just a moment. Testimony there from Megan Price on the witness stand. She was with her husband, Jonathan Price, when attackers approached. The attackers demanded money. Gunfire rang out. Her husband was shot in the heart. She was shot in the leg, as we just saw the photos. Ashley Willcott is still on the line with us. She is paying attention to this case along with us, and we are listening to this testimony with Megan, and she's wearing her his name tape on her shirt, it appears, as she was up there testifying.
That's right. And make no mistake, I think the thing that viewers know and can be reminded of is prosecution and defense prepare their witnesses, right? And so they're going to make certain that they understand how important it is in terms of their appearance, their demeanor, and what they say while they're on the stand, that they need to be honest and truthful, but how they say it and how they present does affect jurors' impressions. And so I wouldn't be surprised if not only does she maybe do that because, or clearly she would do that because she's heartbroken, but also she's been instructed on how to be an effective witness, I presume, while she's testifying.
I agree. You know, it's clear from her demeanor on the witness stand that she's trying to be as honest as possible. She also seems resolute. At sometimes she seems harsh. It's sometimes compassionate. At other times, very, very forceful. But I think above all, she was trying to be as honest as she could.
I don't disagree with you, Aaron. I think that's absolutely true. And I do think that, you know, keep in mind, again, it's 4 years later, and so it's difficult. I think that all of our minds are going to change events or make us think a little differently naturally over time. But I think she's well prepared, and that, like you said, she's testifying as to what she remembers, and the details she doesn't remember, she's still testifying she doesn't remember. And that's very credible.
I just want to let folks know we think that there's been a verdict in the Bradshaw case that we're following. This is an official corruption case out of North Central North Carolina that's being tried in Raleigh, the state capital, because it involves public funds. The accusation there, as perhaps you remember, is that one district attorney, the defendant, was hiring his wife, and apparently under some original discussions that was okay under ethics authorities, or at least under some read of the ethics laws, and it was allowed to continue for about 4 years until the neighboring district attorney was elected in a neighboring judicial district and said, oh, hey, can I hire my wife to work for me? Well, then it sent off red flags, and the word came down that this shouldn't be happening. End of the line? Absolutely not. After that, the two men just hired one another's wives to get around the ethics rules. Ethical? Well, the authority said that it was. The question is what happened next. The accusation there is that the defendant, who you're looking at right there, is accused of allowing the neighboring prosecutor's wife to work, or get paid rather, without really doing any work. So we're going to cut in and listen to some of this right now as a verdict is apparently coming in the Willis-Bradsher case. We saw some of the polling of the jurors there, Ashley, but bottom line, this defendant, Willis-Bradsher, faced 7 total charges. He was convicted on 5 of the 7. So an interesting verdict here. We're still going back and listening to exactly which ones there was a conviction, which one there was not. We know one of them was felonious obstruction of justice. Ashley, what do you make of it? Official corruption case. 2 DAs hiring one another's wives, one of the wives allowed to go to nursing school while drawing a paycheck. Accusations start flying. Just turned into a mess. People pointing the finger back and forth at one another, people not really sure where to assign blame. Jurors the other day were saying that there was a split, at least on some of the verdicts, 11-1. That was one of the words that came out in the midst of this. A lot of questions from jurors throughout, asking for replays of testimony. But bottom line, a conviction on 5 of the 7.
Well, I think, I followed this trial a lot as well, and I really felt like he was trying to make the defense of, listen, at worst, this is bad management, and I didn't have direct control or supervision. Someone else did. Wasn't my fault. Didn't do anything illegal. Cleared it with AOC. No problem with what I did. But the important piece that I think we need to remember is also hearing testimony from the witness, who was the other district attorney who turned state evidence, who said this is what was going on and this is what happened. And I think the jury found that he was right, and his testimony was credible in their mind and believable, and beyond a reasonable doubt, this gentleman did it. This was a trial error, and I really didn't know what would happen. I thought it could go either way. But here we are.
Yeah, it seemed to me that the critical piece of this, Ashley, was that, look, this guy was the guy that was managing the office. The buck has to stop somewhere, and it stopped with him. He was the elected district attorney. He wasn't the payroll supervisor. He wasn't the office manager. He wasn't anyone else. He wasn't the one that was directly approving the time cards here, but he had appointed someone else to specifically approve these time cards, and this person was the only, the underling who approved the neighboring DA's wife's time cards. That was the only person whose cards he approved. I mean, that just looks like a thinly veiled attempt to try to get around something. And look, as I said, the buck had to stop somewhere. It stopped with this guy.
And, that's what I was just going to say. I'm smiling because, come on, with politicians, you're elected to an office, and you're, as a district attorney, you're sworn to uphold that office and the oath of that office. And that includes management. Like you said, even if you let something slip through the cracks, if it's under your watch, ultimately you're responsible for it. And so this was a wife swapping deal. After all the evidence was said and done, I still felt like, in my opinion, the state proved that they had this arrangement and embezzled $48,000, and she got paid for doing nothing.
Yeah, I had to sit back, though, and ask and say, okay, who is the more guilty party here? Is it that defendant who you're looking at live in the courtroom right now, Willis-Bradsher, or is it the Blitzers, the neighboring district attorney and his wife, because they were the ones that were kind of pocketing the most off of this? She was the one that was going to nursing school while sucking down a paycheck. And, why not hold them to the same level of culpability as this guy? The Blitzers did pay the money back, and the district attorney Blitzer, the neighboring district attorney, he admitted to one charge, gave up his law license as a result, and now he's working as a commercial pilot, apparently, flying the friendly skies to somewhere. But, who's really the guilty party here? Is it Wallace Bradsher or is it the Blitzers?
Well, I think they're both the guilty party, Aaron, but, the Blitzers made a decision to turn state's evidence, and we all know that not likely, often individuals who do that get a better deal. They get to bargain and try to get a better deal. I think that's what they did in this case. And from the beginning of the case, when that happened, I've always wondered, why did Bradsher not consider that or think about, is it worth entering a plea and getting a better deal than he faced if convicted of these charges? I don't know the answer to that.
Yeah, and at the end of the day, I came down along that line of reasoning of the buck stopping somewhere. And look, the bottom line is that Cindy Blitzer testified that, and she was the wife of the neighboring prosecutor, she testified that she was not being assigned any more work by this defendant, that she raised that issue with this defendant. She raised the issue with her husband, that they talked to this defendant, and this defendant said, oh, just have her focus on school. So it sounded like the testimony, which I will admit was probably carefully choreographed, it sounded like she had an issue with it and she raised the issue and that this defendant just allowed it to go on. And since he was the one that had control over the purse strings, he was the one who allowed someone to collect a paycheck without working. And perhaps under that theory, that's why this defendant gets the harsher punishment. Ashley, do you agree with that line of reasoning?
I do agree with that line of reasoning.
Yeah, okay. Well, oh, go ahead. Or is that it? You just agree?
That was it. I agree.
Wow, this may be a first. Someone agreed with me without any strings attached to the agreement. I just want to read back the charges to you folks. Guilty of misdemeanor obstruction of justice for Wallace Bradsher, guilty of felonious obstruction of justice, guilty of failure to discharge the duties of his office, guilty of aiding and abetting. Now, the interesting one in here is I think the top charge was obtaining property by false pretense, if I've got that right. That's my understanding. That looks like it was one of the acquittals here. So the jurors appear, based on my quick read of this, and forgive me, folks, it's been a few days since I've dug into the statutes on this one, that perhaps the jurors acquitted this defendant on the top charge. There were guilty counts on 5 of the 7 charges. I did not hear exactly what the sentencing parameters might be for these charges, but that's the bottom line in the Wallace Bradsher case. You see the defendant walking out of the courtroom there. Ashley, this is a bit of an interesting way of doing things. Is this a no jail time kind of thing or what? Normally you see somebody cuffed, but I guess I'd have to go back and triple check my homework on which of the charges he was convicted of. Are they felonies or are they misdemeanors?
Yeah, I'd have to do the same thing. I'll admit to you, Aaron, I haven't looked at that recently to see. Obviously, even if jail time is a possibility until sentencing, he obviously just walked out of the courtroom. He's not going to be in jail until the sentencing phase is completed. But I, too, cannot remember exactly what the potential penalties are in this particular case.
Yeah, you've got a felonious obstruction of justice there, but from what I recall, the top charge was obtaining property by false pretense. The false pretense element is the one that carries the true deceit here, and that was not one of the convictions. So it might just be that these are much lesser charges and could only result in a couple of years. It may be that the jurors compromised here. We did hear at one point that they were really split with one holdout and 11 others. At one point, that was the number that I read. And that would suggest that maybe there was some jockeying and horse trading going on. Maybe they wanted to send a message, hey, we don't like this, but we don't think this is as dirty and as sneaky as some of the other charges out there possibly could be.
That's true. And I also wonder, Aaron, how much of his representing himself played into the jury's decision, because I found that some of his questioning was on point, but generally I found his questions to be very tedious and convoluted. And so I don't know how that played into their mind, but there's that confusion factor to create reasonable doubt for maybe them to say, listen, he may just not be a management guy, and maybe he just turned his head and should have done something about it and ultimately is responsible, but he didn't have the motive or intent to really do this criminal activity. He just wasn't paying attention and managing his office. I don't know that, but I wonder how his representation of himself plays into their decision.
Yeah, you know, we're going to have to dig into this a little bit more. Of course, sentencing will come up. We'll keep an eye on that. So for now, we're going to wrap up, though. Ashley Willcott, juvenile judge and current practicing attorney. We always appreciate your insight. I think you're on the money 99.9% of the time.
Thank you, Aaron. Thanks for having me.
Okay, we'll see you next time. And that'll wrap up our day here a little bit late on the Law and Crime Network. We usually are on the air from at least 9 until at least 5 Eastern time, but when you've got a verdict coming in at the last minute, of course, we do our best to bring it to you. So we will see you back here live tomorrow at 9 a.m. For now, this is Aaron Keller, and for everybody here at Law and Crime, have a good evening.